The top judges in England and Wales say it is up to Parliament to decide whether the law on superinjunctions needs to be changed. The Lord Chief Justice and the Master of the Rolls told reporters that MPs had passed the Human Rights Act and it was up to MPs to make any alterations. David Cameron's spokesman says the government will consider the report published this morning before deciding whether to legislate on privacy issues. Well, talking about how injunctions are dealt with, the committee has said that injunctions can only be granted when they are strictly necessary. They must be kept under review and not become permanent. And members of the media who are the subject of an injunction are to be told beforehand and subject to a confidentiality agreement. Alistair Bunkle is at the Royal Courts of Justice in central London. Alistair, you've been through the report. Where does it leave us in terms of the granting and the public acceptance of injunctions?
Well, I guess in terms of the public acceptance, we'll have to wait and see, and that will only be tested as and when further applications for injunctions or indeed superinjunctions are brought to the courts. This review took a year in the making. The committee was headed by the Master of the Rolls, and on the committee sat a mixture really of people involved in the law, judges, and a representative from the media, a representative from the Guardian newspaper. And really the main points to come out of it are these. Draft guidelines have been set for procedural practice when issuing injunctions, the idea being that at the moment there is some confusion as to how people obtain injunctions, how they arrive at it, and the legal argument that go into it. So the intention is that that will become a little bit clearer. There is also an emphasis being put on members of the media or representatives from media organisations being allowed to sit in court and make their views heard on every single occasion. That's something new, although members of the media have been allowed to sit in court before, and as was pointed out by the Lord Chief Justice, in almost all cases have decided not to challenge the injunctions when they've been put in place, regardless of the fact that the media have been very vocal about them, either on the front pages of newspapers or in television or radio headlines. But what the two judges, the Lord Chief Justice and the Master of the Rolls, pointed out is that judges, the judicial system, can only really operate within the boundaries that are set by Parliament. Parliament set down these guidelines and the judges interpret them to the best of their ability. And they were rather defensive about this, partly I think because they've come in for some flack over the past year or two from various sections of the media for, if you like, for want of a better phrase, for a cliche, bringing in a privacy law via the back door. And there was a little bit of a rebuke, particularly for one one politician, Lord Oakeshott, who asked a question in the House of Lords yesterday via a peer colleague of his, a Liberal Democrat peer, about an injunction that concerns the former Chief Executive of the Royal Bank of Scotland, Sir Fred Goodwin, which should have blew this injunction out into the open and resulted in it being lifted by the High Court yesterday afternoon. And the Lord Chief Justice had something to say about that.
It is, of course, wonderful for you if a member of Parliament stands up in Parliament and says something which in effect means that an order of the court on anonymity is breached. But you do need to think, do you not, whether it's a very good idea for our lawmakers to be in effect flouting a court order just because they disagree with the order, or for that matter because they disagree with the law of privacy which Parliament has created.
One of the more notable aspects of the review, if you like, was something that actually wasn't in the review, and that's the function and the effect of social media on injunctions, on superinjunctions, particularly Twitter, of course, which has been in the headlines for the last couple of weeks. And as you'll hear here, they will explain that Twitter is a problem, of course it is, and it's a growing problem. But in the opinion of the review committee, it doesn't yet have the reach that mainstream media does. And therefore it doesn't have such a profound effect on the public psyche. And also it isn't trusted in the same way as mainstream media is. And so although social media will need to be visited at some point in the future, it was decided that at this stage it wasn't considered when drawing up the review.
At the moment, the law seems to be that even if the information which is the subject matter of the injunction is on the web or may go on the web, that is by no means the same degree of intrusion onto privacy as the story being emblazoned on the front page of a national newspaper, which people trust more and has far greater circulation than most bloggers and tweeters. It is a problem, however, and I can well understand the press's concern that on the one hand the print press is prevented from telling a story when it is available on the web. And that is a problem, and it's one that we're going to have to face and deal with as the matter develops.
We were given an advance copy of the report, and when we glanced through it, I think the one thing that really sort of raised eyebrows amongst the journalists in attendance was the figure that, at least according to the committee, only 2 super injunctions have been issued since January 2010. And I bet if you ask any member of the public who have read headlines over the past year or two, the general feeling is that super injunctions have been issued far more widely and far more freely than that. So I think that goes to show perhaps that there has been misreporting of the issue, although I think because of the foggy nature of it, no deliberate misreporting of the issue. And the real intention of this review is to bring clarity and to bring openness.